Please be seated. The sitting is now open. This morning, the court will hear the second part of Chile's first round of oral argument. I will now give the floor to Mr. Wordsworth to continue his presentation. You have the floor, sir.
Mr. President, members of the court, yesterday I was taking you to some of the key documents to show what Chile had really said it was open to by way of a negotiation, including as to the compensation it was discussing with Bolivia and the President of the United States of America, the land for water formula. And of course, this was all hugely politically sensitive. I move on now to the events subsequent to the June 1950 notes. 3 points. First, Bolivia in no sense acted as if it had rights or obligations under a newly concluded treaty. Indeed, its conduct was marked by a telling lack of action. Bolivia did not submit the notes to its Congress for approval as a treaty or other international agreement, as would have been required by the constitution then in force in Bolivia. Bolivia did not respond to the note in any way. It did not submit a proposal stating what it was looking for in terms of sovereign access. So it obviously did not consider itself legally bound to perform, to get the negotiation underway by stating its position. Instead, it elected to do nothing. And it is also elected not to tell this court why. There may be an insight to be gained from the reports back to Bolivia's foreign minister, from Bolivia's ambassador in Santiago, in particular the report of 11th July 1950, where the ambassador said as follows: "I think it is urgent to inform the government of the United States, as we were asked to do by the Chilean Foreign Ministry, about the negotiations that have been initiated and our country's willingness to reach the understanding of which President González Videla informed President Truman." Now, that's a reference to a request that was made by Chile in a separate communication of 20th June 1950. And so far as we can tell, Bolivia never contacted the USA as requested by Chile. Bolivia's ambassador continues, "Finally, it is indispensable that this foreign ministry, the Bolivian foreign ministry, send me the authorization I mentioned in my cablegram number 152 of 28th June, almost 20 days ago, to enter the second stage of negotiations that has currently been paralyzed by the answer contained in your cablegram number 91 of 24th June. Now, I note that in the sessions earlier this week, you heard nothing about it being Bolivia paralyzing negotiations in June 1950. One wonders, what was the answer in that Bolivian Foreign Ministry cablegram of 24th June that, according to Bolivia's own ambassador, had the effect of paralyzing the second stage of negotiations? We don't know. Bolivia has elected not to put this before the court. And the same goes for the Bolivian ambassador's cablegram of 28th June 1950, which would have revealed the contents of what Bolivia's foreign ministry had been saying on 24th June. And yet, if there were a serious case on Bolivia having believed that a binding agreement had been reached, or on a binding unilateral declaration having been made, or even on demonstrating the reliance necessary for an estoppel, the court would have to see the documents generated by Bolivia to show how it in fact reacted to receipt of Chile's 20th June 1950 note. or whether in fact it was willing to commit, as Chile had requested, in general terms to what had been discussed between Chile and President Truman, that is, an exchange of land for water. Finally, and this we do know, Bolivia did not insist on performance by Chile in what is now said to be a binding obligation to negotiate. There was no negotiation pursuant to this supposed treaty. And Bolivia did not react to that fact by seeking in some way to enforce the alleged obligation, in stark contrast to the action of Greece in Aegean Sea, or Qatar in Qatar and Bahrain. Well over a decade went past before it even suggested, in the first of one of less than a handful of occasions, that the June 1950 notes contained some form of legal commitment. I move to my second point on subsequent events, which is simply to recapitulate that, as all the documents from the second half of 1950 show, there was a very significant public hostility to any negotiation, as indeed the two states had previously feared there would be, in both Chile and Bolivia, I should add. My third point, Chile's reaction confirmed that it did not consider that it had made a legally binding commitment to a negotiation. On Tuesday, Professor Forto referred to a statement of Chile's foreign ministry made on 11th July 1950. The aim of the statement was to try to calm the public reaction. Chile said, "Chile has expressed on different occasions, and even at the meeting of the League of Nations, its willingness to give an ear in direct contacts with Bolivia to proposals from this country aimed at satisfying its aspiration to have its own outlet to the Pacific Ocean." This traditional policy of our foreign ministry, that is, the willingness to give an ear, in no way diminishes the rights conferred on Chile by the treaties in force. The current government is consistent with the diplomatic precedents recalled here, and therefore is open to enter into conversations with Bolivia about the problem referred to. No suggestion there of any binding obligation to negotiate. And many similar statements were made around the same time. On 19th of July 1950, Chile's president made a statement in Vea magazine, to which Professor Chemillier-Gendreau referred on Monday. He said, "We have to make things clear. The government has not resolved anything concerning this issue. The only truth is that in keeping with the traditions of the Chilean Ministry of Foreign Affairs and ratifying my profound American spirit, I have never refused to hold conversations on Bolivia's port aspirations. And that likewise does not help Bolivia's current case on existence of a legal obligation." The president then explained in a passage of interest as to the continuing impact of the 1904 peace treaty in any negotiation, "Such conversations shall not revolve around treaty revision, because we have no unresolved issues with Bolivia in that respect. All treaties signed have already been performed over time, and nowadays they're just part of history. Consequently, no revision of any kind may be admitted. So, I stated, while acting as delegate in San Francisco, and all Chileans will surely remember that this battle against treaty revision was won by our delegation from start to finish." So an interesting historical insight there. He continues, "The preamble to the Charter of the United Nations reads as follows: We, the peoples of the United Nations, determined to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. Thus, the tone of the conversations with Bolivia will be none other than that of friendly, amiable dealings based on providing compensation to Chile." And this shows once again how disconnected Bolivia's case on an unfulfilled historical bargain is from the documentary record. It also explains further what Chile was meaning when it referred in its note of 20th June 1950 to safeguarding the de jure situation established in the treaty peace of 1904. As Chile saw matters, and as indeed is consistent with the facts, with the preamble to the UN Charter, and with Article 6 of the Pact of Bogota, all the issues with respect to the period prior to the 1904 peace treaty had been dealt with in that treaty. If there were to be conversations with Bolivia, these were to be friendly, amiable dealings based on providing compensation to Chile. One last document from this period. Professor Forto singled out for special treatment a statement made by Chile's Foreign Minister, Walker, that was reported on 13 September 1950. You weren't taken to the opening paragraph of this lengthy statement, which makes plain that its whole purpose was to convey the point that nothing had been formally agreed with Bolivia. The Foreign Minister said, efforts have been mainly made to distort the nature and ends of the preliminary diplomatic démarche carried out to address the Bolivian question, and the most absurd of suspicions have been created in that regard. These unfounded assertions have reached the point of sending information to Arica on the effect that the Chilean government has resolved to hand over that port, regardless of my energetic public refusal to such absurd and evil statement. Also, an attempt has been made to overlook the fact that, so far as to be valid and binding, anything that is agreed to by the foreign ministries must be subjected to the ratification of the National Congress, which is the sovereign entity to approve or reject these measures, and has, as a matter of fact, exercised this faculty on different occasions, without causing interruptions in our foreign affairs. And of course, there was no such ratification of this preliminary diplomatic démarche. I move on to the so-called Truco Memorandum of 10th July 1961. This adds nothing, and the emphasis that Bolivia's council placed on this document earlier this week would have come as a surprise to Bolivia's one-time foreign minister, Arce Quiroga, who actually attended the meeting of 10th July 1961. Chile's ambassador, Truco, described what happened as follows. As for the port issues, Minister Arce Quiroga clearly explained the position of President Paz Esterenzo. This government and the MNR are against the demagogic use of this matter. We believe that this problem can only be solved by the mutual understanding of the parties, among which I include Peru and Chile, in a three-party operation. Since this is not a current problem, we think that we should not bring it up without serious deliberation directly with you. So none of this suggests a binding obligation on Chile to negotiate. The account continues. He asked me what we thought about it, and I replied that we had always refused to resort to third parties, and that we had always shown our willingness to listen to Bolivia directly. To that end, I read the items on the copy that I carried in my pocket, and that's the so-called Truco Memorandum, which contained the express instructions I'd received from the office. As requested by our Ministry of Foreign Affairs, I did not mention the lack of response to the Chilean note of June 1950. Minister Arce Quiroga took note of my statement. Just as with the unsigned memorandum on which Bolivia relies, there is no suggestion from this account, the only account of the actual meeting, that any legal obligation was somehow being formed or confirmed. Months later, and following a change of its foreign minister, Bolivia sought to rely on the Truco Memorandum in the context of the disintegrating diplomatic relations over the Lauca River. In a memorandum of 9 February 1962, Bolivia purported to express its full agreement to negotiations, but on its own terms, referring to satisfying the fundamental need of Bolivia, not on any basis that had ever been put forward by Chile. Just as with Chile's note of 20th June 1950, Bolivia was not content with and did not accept what Chile had seen as acceptable. On Tuesday, Professor Ramiro Bretons told you that a few weeks later, the Chilean foreign minister declared that the problem of Bolivia's landlocked status did not exist for Chile. The document that he referred to, an aide-memoire of 16th March 1962, in fact shows something rather different being said by Chile. The Minister of Foreign Affairs, that is of Chile, of course, added that his government did not accept linking the case of the Lauca River with the so-called Bolivian landlocked status problem. With respect to this point, there is no problem for Chile since its limits with Bolivia were established by international treaties in force. He added that Chile has never refused to listen to Bolivian aspirations. 1 month later, in April 1962, Bolivia announced the rupture of diplomatic relations between the two states in protest at Chile's use of waters of the river Lauca. In March 1963, Bolivia sought to make resumption of diplomatic relations conditional upon a commitment on Chile's part to the negotiation on the port problem. But as Chile's foreign minister explained in a speech of 27th March 1963, Bolivia's acts had led to such a deterioration in relations that, I quote, "the favorable disposition that our country showed in 1961, as in previous times, to listen to Bolivia, no longer exists." When later in 1963, Bolivia alleged for the first time that Chile's note of 20th June 1950 established some form of legally binding commitment to a negotiation, that was rejected by Chile. Some 4 years later, in April 1967, President Barrientos of Bolivia claimed in a note to the President of Uruguay that the 1950 notes constituted a commitment. Chile again and very publicly rejected this. In a lengthy letter from Chile's foreign minister to all the ministers of foreign affairs of Latin America, it was stated, "Negotiations did not even start. Bolivian and Chilean public opinion reacted so violently that Ambassador Austria of Bolivia and Minister Walker of Chile were forced to explain that there had been no commitment and that negotiations had never been opened." This is what President Barrientos calls Chile's commitment. If ever there was a communication that called for some reaction, if a reaction could be made, it was this. And yet Bolivia said nothing. And for good measure, I note that when Bolivia referred to the 1950 notes before the OAS in 1987 and 1988, Bolivia made plain its position that Bolivia had no legal rights in play. And again, Bolivia did not respond. And Bolivia would have had no legal basis on which to respond. Chile did not legally bind itself to a negotiation in its note of 20th June 1950. The importance and sensitivity of the underlying issue is reflected in Chile's carefully chosen tentative language, and indeed in the public furore that followed. Bolivia's current case, to the contrary, is counter to the actual terms in which the June 1950 notes were cast, to the circumstances in which they were drawn up, and to the events, or rather non-events, that followed. And even if Bolivia could get beyond the first stage of showing a legal obligation, the 1950 notes could be of no assistance to Bolivia today. At best, there would have been an obligation current in 1950 to enter into a negotiation. That cannot somehow translate into an obligation that is, one, enduring today, and two, requires negotiation on quite different terms, and all the more so when, three, there was in fact a negotiation in the period 1975 to 1978, which failed because of Bolivia's wish to rewrite the accepted basis on which that negotiation was to be held. And it is to that negotiation that I now turn. The Joint Declaration of Tirana of 8 February 1975, which marked the resumption of diplomatic relations between Bolivia and Chile, is at tab 51 of your folders, now on the screen. According to Bolivia Today, this is a treaty containing another entirely open-ended obligation on Chile to negotiate, capable of enforcement many decades down the line. Back at the time, matters were seen rather differently. For example, according to a statement of former Bolivian Foreign Minister Guevara Arce on the Joint Declaration, which was made to Associated Press and reported in Bolivia's Los Tiempos newspaper on 12 February 1975, just as a savage who gives away gold nuggets in exchange for glass necklaces, President Banzer has gifted to Chile the resumption of diplomatic relations, receiving in exchange, officially for Bolivia, the vaporous and imprecise phrases of a joint declaration. So one turns to the declaration itself. In its paragraph 1, the Joint Declaration records that General Pinochet of Chile met with General Banzer of Bolivia, this being a time when both countries were under military dictatorship. Paragraph 1 describes how these two have met with the purpose of exchanging points of view on matters of interest to both countries and on the continental and worldwide situation. This language, exchanging points of view, could scarcely be further from suggesting an intention to create binding obligations. From paragraph 2, one sees that the meeting has permitted the identification of important common ground. So, some progress. But again, this is not language indicating that any binding agreement had been reached. The key paragraph for Bolivia is paragraph 4. It records, both heads of state, in that spirit of mutual understanding and constructive motivation, have resolved to continue the dialogue at various levels, to seek formulas for solving the vital matters that both countries face, such as the landlocked situation that affects Bolivia, taking into account their reciprocal interests and addressing the aspirations of the Bolivian and Chilean peoples. Now, it's important to approach this wording with a little more rigor and also realism than Bolivia has been advocating. And there's a useful comparison to be made with the 1990 minutes at issue in the Qatar-Bahrain case. 2 points as to these. First, there is the obvious point that there is no clear statement of a specific course of action having been agreed, as there was in the 1990 minutes in Qatar-Bahrain. Secondly, in that case, the two states had been working together with the good offices of Saudi Arabia to fix on a means of settling their dispute, and were meeting in 1990 against a backdrop where each had already formally accepted the principle that all the disputed matters shall be referred to the International Court of Justice at The Hague for a final ruling. Here, by contrast, the two states had long since broken off diplomatic relations, and it is simply implausible that they would have been intending to flip a switch so that their relationship went from full off to full on, with the new position hardwired through the adoption of binding obligations on the hugely sensitive issues of Bolivia's landlocked status and the resumption of diplomatic relations, which was dealt with in paragraph 6 of the declaration. On Bolivia's case, if General Banzer had changed his mind when he returned to La Paz, deciding that Bolivia would not in fact normalize diplomatic relations because of, for example, a hostile public reaction in Bolivia, he would nonetheless have been legally bound to do so, and that cannot have been what was intended. I made the point yesterday that the very sensitivity of the issue of Bolivia's landlocked status made it unlikely that the two states would have been willing to take on binding obligations to negotiate on that matter in 1950. Well, this was even more the case in 1975, after a dozen or so years of ruptured relations. A public statement of 19th April 1976 from Bolivia's foreign ministry makes the point. The relevant background is that the military government's approach to the negotiation is being attacked by no less than 3 former Bolivia presidents. You see from the introduction that this is a clarification made by Bolivia's foreign ministry to respond to what are called untruthful assertions or comments. There's a description of the government's policy on sovereign access, and at paragraph 3, a reference to the guidelines for the negotiation, and I'll be coming back to those shortly. Then at paragraph 4, there is a reference to the President's conceptual basis for the negotiations. And at subparagraph D, the statement, "The government of the armed forces of the nation has not undertaken any commitment in this matter without the prior authorization of the people's opinion." That statement reflects the underlying reality. It would have been politically imprudent in the extreme, even for a military dictatorship, to take on legal obligations of any kind on this matter without public support. And that was all the more true at the very moment of the Chiranya Declaration, when the two states were just seeking to renew diplomatic relations. Mr. Akhavan made a point that the joint declaration was included in the treaty series of the Ministry for Foreign Affairs of Chile. But as Bolivia well knows, this series contains a variety of documents, including Chilean internal documents, which are not treaties and do not contain any legal obligation. As Bolivia also knows, the Joint Declaration of Chiranya was not ratified or otherwise treated by Chile as a treaty under its domestic law, and there is no suggestion that it was so ratified or so treated by Bolivia either. Mr. Akhavan also sought to make something of the fact that on 6th August 1975, and I use his words, the OAS unanimously proclaimed that the landlocked situation which affects Bolivia is a matter of continental concern for which a solution must be found. The only trouble is that the words "for which a solution must be found" are the words of Mr. Akhavan, whereas the OAS in fact said, "and all the American states offer to cooperate in seeking solutions." Rather different wording, one might think. 3 more specific points on paragraph 4. First, there's no mention anywhere to the so-called international agreement made up by the June 1950 notes. Had the two heads of state considered such an agreement to be in place, they would have been expected to make some explicit, or at least some implicit, reference to it. And they didn't do so. And it is plain that that was quite deliberate. On Monday, Professor Chemillier-Gendreau referred to a meeting between Bolivia and Chile of April 1971, and to drafts for a joint declaration submitted by Bolivia 4 months later. As to this, Bolivia had 2 alternative wordings, and you can see them up on the screen and at tab 55 of your judge's folder. The first alternative: the governments of Bolivia and Chile have resolved to continue the negotiations agreed to in the notes exchanged by both governments on 1st and 20th June 1950, and signed by the Foreign Minister of Chile, Mr. Horacio Walker-Lorraine, and the Bolivian Ambassador to Chile, Mr. Alberto Austria Gutierrez, to which end the 2 governments hereby declare that these documents are in full force. so wording that plainly does not find its way into the 1975 joint declaration. The alternative proposed by Bolivia: the governments of Bolivia and Chile resolve to formally commence a direct and bilateral démarche to negotiate Bolivia's own and sovereign access to the Pacific Ocean with due regard for both countries' reciprocal interests. Again, nothing like the actual wording of paragraph 4. Professor Forto affected to find support in this 1971 draft for his case on continuity between the 1950 notes and the 1975 Chiranya Declaration, which is puzzling indeed, because it is self-evident that the wording that was eventually considered acceptable and incorporated into the 1975 Declaration could scarcely have been more different from either of the 1971 draft alternatives of Bolivia. Secondly, and following from what I've just said, paragraph 4 is simply not formulated in the language of international agreement, any more than the document taken as a whole. The two states have used the cautious language that you'd expect to see, where a decision is being made to normalize diplomatic relations after more than a dozen years, and where there is an intent to make to the world an entirely non-binding political statement. So they have said, have resolved instead of have agreed. To continue the dialogue at various levels instead of to negotiate. And to seek formulas for solving instead of to reach agreement on. Professor Romero Bretons spent a great deal of time on Monday seeking to show that have resolved, han resuelto in the original, could mean have decided or have agreed, as well as the more obvious have resolved. The extract of the Royal Academy Dictionary that he referred to did not, so far as I could see, give have agreed as a meaning. But that, of course, is not decisive. And Chile's case is not that have resolved could never be used to establish a legal obligation. More pertinently, the declaration uses have resolved on various occasions from which it appears plain that no legally binding force was intended. Thus, in addition to paragraph 4, in paragraphs 5 and 6, the presidents said they have resolved to continue developing a policy in favor of harmony and understanding so that in a climate of cooperation, a formula for peace and progress is jointly found in our continent. And then, at paragraph 6, have resolved to normalize the diplomatic relations at the ambassadorial level. And these cannot tenably be read as binding obligations that each state could have sought to enforce as it saw fit. Thirdly, even if one was somehow to accept that this is the language of international agreement, it wouldn't help Bolivia. The obligation would be to continue the dialogue at various levels and to seek formulas for solving the vital matters, of which one is the landlocked situation that affects Bolivia. But Bolivia's case is about an alleged obligation to negotiate specifically sovereign access. Professor Romero Bretons told you on Tuesday that it was implicit in the declaration, puisque c'est bien de cela qu'il s'agissait. Autrement, la Bolivie n'aurait pas repris les relations diplomatiques. He didn't refer to any document. A useful reference would have been to President Banza's statement on 5th February 1975, recorded in the press as follows. The landlocked problem of Bolivia is not a condition to resume diplomatic relations with Chile, stated Bolivian President Hugo Banza earlier today. 72 hours before meeting his Chilean colleague, Augusto Pinochet, General Banza built a silver bridge for an exchange between the ambassadors of both countries. Banza declared verbatim the maritime reintegration is not a basic condition for resuming relations. So rather the opposite of what you were told on Tuesday. And the simple point here is that the actual terms of paragraph 4 bear no relation at all to Bolivia's claimed obligation in this case. According to General Banzer in an interview on 29th December 1975, the Act of Chirania does not include a categorical commitment by Chile to resolve Bolivia's landlocked situation. That seems plain enough, yet on Bolivia's case, it does. To support that case, it sought to make a great deal of the wording used by the press secretary, Federico Willoughby, and of the tentative views expressed on the subsequent guidelines by well-known Chileans, who were then rather touchingly youthful academics. But it is President Banzer who signed the joint declaration, and what he said on 29th December 1975 is, with respect, by far the more convincing description. As to what happened next, the two states worked on guidelines for a negotiation. I'll take you to these in a moment, but first the parties' respective positions. Chile says that these did not create any legal obligation. As to Bolivia's case, this is very unclear, but as I understand matters, it is that the guidelines are legally binding, so as to establish an obligation to negotiate, but not legally binding so as to one of their central and express tenets, which was that Chile was only willing to negotiate on the basis that any cession of territory by it would be compensated by a cession of territory by Bolivia. In other words, binding guidelines, but only so far as concerns the parts that suit Bolivia's current case, which is not a very attractive position to adopt. Bolivia's proposed guidelines were formulated in August 1975 and are at tab 58 of your judge's folder. According to paragraph 1, the proposal was put forward to specify the guidelines for a negotiation. According to paragraph 7, Bolivia was willing to consider as a fundamental matter of the negotiation the contributions that may correspond as an integral part of an understanding that takes into account reciprocal interests. Chile's position was presented at a meeting of plenipotentiaries on 12th December 1975, and Bolivia responded positively on 16th December. As you can see, Bolivia stated that it accepts the general terms of the Chilean government's response. Then, in the next paragraph, Bolivia reiterated a request for a written response on the same terms as the one stated orally by Your Excellency at the meeting on Friday, the 12th of this month, and that constitutes the basis for the agreement that our two countries are negotiating. And this was done pretty much right away in a letter of 19th December. You see the complete document at tab 60 of your folders. The key paragraph is paragraph 4, which reiterates what had been presented a week earlier. At subparagraph A, you can see that the starting point for President Banzer, which Chile was seeking to respond to, was to consider the current reality without reviving historical antecedents. So, a fresh start, not the performance of some historical bargain or a reference back to the 1950 notes. I note in passing that Mr. Akavan told you on Monday that, in a diplomatic note dated 19th December 1975, Chile once again proposed the 1895 formula. Well, that does not quite appear to catch how these states were seeing matters. As subparagraph B then makes plain, the 1904 peace treaty was very much to remain central in the relations of the two states. Then, as recorded in paragraph 4C, as His Excellency President Banzer stated, the cession to Bolivia of a sovereign maritime coastline linked to Bolivian territory through an equally sovereign territorial strip would be considered. And the broad outline of what was to be considered was then set out in paragraphs 4D through to 4F. As per paragraph 4D, Chile would be willing to negotiate with Bolivia the cession of a strip of territory north of Arica up to the Concordia line, based on specified boundaries. In paragraph 4E, Chile unsurprisingly rejected as unacceptable the cession of territory that could affect in any way the territorial continuity of the country. Then at paragraph 4F, the cession to Bolivia, described in section D, would be subject to a simultaneous exchange of territories. That is to say, Chile would at the same time receive in exchange for what it hands over a compensatory area, at least equal to the areas of land and sea ceded to Bolivia. Bolivia did not then reply to say, no, you've misstated our position. We do not agree to negotiate on the basis of a territorial exchange. Of course not. That was a fundamental part of the basis for the negotiation. To the contrary, in fact, 2 days later, General Banzer informed the Bolivian public as to Chile's position on an exchange of territories, and stated in his message that the proposal was under responsible consideration, and that the government considers that the reply of the Chilean government to the Bolivian proposal constitutes an acceptable global basis for negotiations. Now, one might have expected the guidelines to be at the heart of Bolivia's case. The two states had settled on the general terms for a negotiation on sovereign access to the sea, with the basic lines of the quid pro quo set out in writing. There was then a negotiation by reference to the guidelines. This is a unique episode in the relations between the two states. And yet, Bolivia now tries to pull back from what the guidelines actually said, just as it did in 1978. At an obvious level, this is no doubt because the guidelines are, 1, inconsistent with Bolivia's case on who was to blame for the breakdown of the negotiation, since all Chile did was to stick to the central tenet of the guidelines. 2, inconsistent with the relief now claimed by Bolivia, which ignores altogether the compensation that Chile considered essential. And 3, entirely inconsistent with Bolivia's case on the so-called historical bargain. But there's a further point to be made. Bolivia's case depends on establishing an intent to establish legal relations or the existence of a statement on which it could reasonably rely and did rely to its detriment. That requires a close focus on the wording of documents made by the two states, in particular at the isolated instances when the two states were most closely focused on the issue of sovereign access. Yet it is precisely at these moments that Bolivia asks the court to step back from the actual words on the page. Indeed, elects not to take you to the documents, because the detail shows that when Chile was actually willing to negotiate with respect to sovereign access, this was on the basis of material compensation, notably water or land. This was an essential requirement, not least because it could make consideration of a cession of territory politically and publicly acceptable in Chile. And no less to the point, the government of Bolivia was also subject to an imperative in terms of negotiating towards an outcome that would be acceptable to its domestic audience. These competing imperatives were decisive in terms of whether and on what basis each state could enter into a negotiation, and what in fact transpired once a negotiation was contemplated. Even in the unique period of the mid-1970s, when both states were subject to military dictatorships and there was no democratic accountability in either state, the negotiation failed precisely because of these competing imperatives. In the event, because Bolivia decided it would not meet the position that it had accepted on territorial exchange. Bolivia now wishes to cast this failure in different terms, but the true position is that the pain-free sovereign access to which Bolivia now says it is legally entitled has never been and could never have been available. I turn to the conduct of the negotiation, which took place between 1975 and 1978, to the point where it failed because Bolivia refused to continue discussions on the basis of the accepted guidelines, rendering futile any further attempts at reaching a negotiated outcome. The court will see the full record of interactions in the Chiraña period set out with reference to both Bolivian and Chilean contemporaneous documents in Chile's counter-memorial and in its rejoinder. I just want to make 4 key points. First, in the initial months of engagement, Bolivia explicitly reaffirmed its acceptance of Chile's proposed guidelines, including the condition on territorial exchange, and it is perplexing that Bolivia seeks to suggest that this is in doubt. On your screens, you see one of the headlines of the Presencia newspaper, published in La Paz on 29th December 1975. The headline makes the point plainly enough. Negotiations will be held with Chile on the basis of territorial compensation. And you can see also that this is a transcript of a radio interview with General Banzer at a round table with newspaper publishers and directors of radio stations, broadcast on 28th December 1975, and he is saying, in terms to the widest possible audience, we have accepted the Chilean proposal, globally considered as a basis for negotiations. We also consider that an exchange of territories is part of that fundamental basis. Professor Forto made a half-hearted attempt on Tuesday to argue that the globally accepted basis did not include the condition of territorial exchange, but that is just incorrect. Statements to similar effect on the accepted basis of territorial exchange were reiterated by General Banzer and also the Bolivian foreign minister in the days and months that followed. And it was stated as early as January 1976 that studies by technical subcommittees were underway so that Bolivia could propose an area for exchange that it considered most suitable. In a meeting on 27 September 1976, General Banzer confirmed that those studies had been concluded. In the same meeting, Chile agreed to exclude the 200 nautical mile patrimonial sea from the area to be taken into account in determining the area of the size of territory to be exchanged. Bolivia's president considered that Chile's position was fair and that it should be accepted by what he called the notables of Bolivia. As to this, he's recorded as saying at this meeting, "These are the people," this is the notables, "who gave me the mandate to obtain a sovereign outlet to the sea for Bolivia. I have obtained it under conditions I deem fair in times of peace. If they accept the terms that I convene with Chile, perfect. If not, the historical responsibility of their rejection and the failure of the negotiation will lie with them." That's the notables again. as the President of the Republic would have presented them with the only feasible solution through peaceful means. And yet, you are now being asked to accord this historical responsibility to Chile. There's a further point, which is that Bolivia has a case on degradation of a supposed obligation under the 1950 notes, due to the fact of the position accepted by Bolivia as to territorial exchange. It was even said on Tuesday that Chile had acted in bad faith in systematically reducing the object and scope within which it was prepared to negotiate. It is as if Bolivia feels free to make any allegation, however serious, free from any need to look at the actual facts. I move to my second key point. Pursuant to Article 1 of the 1929 Supplementary Protocol with Peru, Chile and Peru agreed not to cede any part of Tacna or Arica to any third state without previous agreement. So, Chile made good faith efforts to consult with Peru, including in 2 rounds of meetings in April and July 1976. But Peru was, perhaps naturally enough, concerned with its own interests. On 18th November 1976, Peru put forward its own proposal, which you can see on this sketch map. At the base of a new Bolivian corridor, Peru wanted an area of shared sovereignty. In other words, Peru wanted to acquire sovereign rights in an area of Chilean territory that Chile was considering ceding to Bolivia. On 22nd November 1976, Chile and Bolivia met to discuss this proposal, which was antithetical to both states' interests. And you can see General Banzer's reaction on screen. He rejected the Peruvian proposal and understood perfectly Chile's position against it. He said that if negotiations failed, we would publicly acknowledge Chile's positive attitude. The evidence of that meeting has been on the court's record since July 2016, and it has been persistently ignored by Bolivia. And one wonders whether Bolivia's counsel will finally deal with this evidence next Monday. On 26 November, consistent with what had been discussed with Bolivia, Chile responded to and rejected Peru's proposal, asking Peru to respond to the proposal as originally sent by Chile back in December 1975. But Peru did not accept this. On the same day, Peru made a statement that was published in the El Diario newspaper to say it was maintaining its position. This was consistent with what Peru's foreign minister had said in a long interview published in La Prensa in Lima. And you can get the gist of Peru's position from the 4th page, where the foreign minister says, "But as we have very clearly indicated, the sine qua non condition for meeting all the other requirements is this area of shared sovereignty." Earlier this week, Bolivia told you that Peru was open to negotiation on its proposal, relying on Peru's letter addressed to the court in the context of this case, sent in 2016, and that's at tab 67 of your folder. Bolivia drew your attention to paragraph 4.4 of that letter, but it referred to a passage that was just setting out Peru's position as it saw it under the 1929 Treaty of Lima, i.e., that Peru could accept or reject and also discuss a proposal impacting on sovereignty over Arica. More to the point, in the passage of the letter, Peru also included a footnote referring back to the statements it made in 1976, including the statement made by its foreign minister that I've just taken you to, indicating that an area of shared sovereignty was, in fact, an immovable condition for Peru. So we invite you to read the letter in full. I move on to my third key point from the record of the negotiation. Less than a month after Chile delivered the agreed response to Peru, Bolivia abruptly and unilaterally sought to reject the guidelines for negotiation, seemingly because of a change in public opinion in Bolivia against territorial exchange. But this particular shift in position was short-lived. Within 2 weeks, Bolivia returned to the discussions with Chile on the basis of the accepted guidelines, and discussions on this basis continued throughout 1977. On Tuesday, Bolivia placed some emphasis on a joint declaration issued by the foreign ministers of Bolivia and Chile on 10th June 1977, suggesting that the two states reiterated their commitment to negotiate sovereign access, but without referring to territorial exchange. The declaration is at tab 68 of your folders, and again, it's another document that we do respectfully ask you to read in full. It is the sort of wordy and unattractive declaration that is made where military dictatorships meet and see fit to make statements on the importance of human rights. It is baffling that Bolivia is relying on this document, the language of which is quite inconsistent with either the guidelines or the Chiranya Declaration having established any legal obligation. And consistent with what I've just said, after June 1977, Bolivia continued to confirm that it was negotiating on the basis of territorial exchange. For example, in early August 1977, General Banzer affirmed that negotiations between the two states were continuing on the basis of the guidelines adopted in 1975, noting that the two states were not looking for a new proposal. We have ratified what we have done and what we have proposed, and we will maintain those terms. The following month, the heads of state of Chile, Bolivia, and Peru met in Washington, D.C. And just 2 days later, General Banzer explained to the press that it would be for Bolivia to select the territories to be exchanged with Chile. But then, in late December 1977, General Banzer sought once again radically to revise the basis for the negotiation, asking Chile to abandon the condition of territorial exchange. And it's useful to note that this was all in the language of proposal and request, and that General Banzer recognized that it was not for Bolivia to insist on the establishment of new conditions. He said, "The establishment of new conditions to overcome the current stage and lead us to the aims we set at the meeting of Chiranya, aims, one notes, not obligations, is not in the hands of Bolivia." Chile's position, however, was that the accepted guidelines remained the only viable and realistic way to satisfy the longing of Bolivia. And in this respect, it's recalled that the Chilean government, too, had its own imperative that any agreement on sovereign access had to be domestically acceptable. And this leads to my fourth key point. Bolivia caused the negotiations to fail. On 17th March 1978, General Banzer suspended diplomatic relations with Chile, making particular reference to Chile's refusal to change its position on territorial exchange. Chile's reaction expresses bafflement. In a declaration issued the following week, Chile stated, "It is incredible that the Bolivian government has a nebula about this," that is, the condition of territorial exchange. "In circumstances when that condition, territorial compensation, has been reiterated personally from president to president, from foreign minister to foreign minister, and to the two ambassadors that Bolivia had in Santiago in the past 3 years." As to what happened next, the important point is that Bolivia never sought to return to the negotiating table on the basis of territorial exchange. nor sought to negotiate with Chile on the basis of the joint declaration and the accepted guidelines. And diplomatic relations have remained severed ever since. Now, Professor Forto sought to make the argument on Tuesday that despite this unpromising set of facts, the supposed obligation to negotiate under the 1975 Joint Declaration and/or the guidelines remained, and indeed remain, in full force. Yet this is a situation where Bolivia removed the whole basis for the negotiation through its refusal to negotiate any longer on the basis of the accepted guidelines, and for good measure broke off diplomatic relations. Professor Forto spent a fair amount of time discussing what Bolivia considers to be the appropriate legal standard, and suggesting that the issue was not whether further negotiations had become futile. And that was perfectly interesting. But regardless of whether the appropriate standard is one of futility, as appears from the court's most recent jurisprudence, or is a requirement to negotiate as far as possible, as in the railway traffic case, or as Paul Reuter has put it, les perspectives de succès semblent définitivement écartées, with the result that l'obligation de négocier est caduque, faute d'objet, the test is plainly met. It is strange indeed to suggest that a supposed obligation to negotiate under Chirania could be brought back to life decades after Bolivia's acts brought the negotiation to an end, and all the more so in circumstances where there has never been the faintest suggestion that Bolivia wanted to renew negotiations on the basis that it had previously accepted. And I would add, the entirety of Professor Forto's argument was based on the predicate that the 1975 Joint Declaration and/or the guidelines established an obligation to carry out a never-ending cycle of negotiations, whereas there is no basis for that whatsoever in the language of those two documents. If somehow either could be construed as establishing an obligation to negotiate, there is not a trace anywhere of any obligation to reach a result satisfactory to Bolivia. Professor Forto also focused on Article 59 of the Vienna Convention, concerning the circumstances in which one treaty will supersede and terminate an earlier treaty. It is plain to Chile that if Bolivia could indeed point to treaties concluded in 1950 and 1975, the latter would supersede the former, including on the basis of incompatibility. Professor Forto argued, however, that the supposed obligation under the 1975 Declaration and/or the guidelines was not such that it would be incompatible with the supposed obligation arising out of the 1950 notes. Now, that is a remarkable argument. It is correct that the 1950 notes foresaw non-territorial as opposed to territorial compensation. And it is precisely because the supposed obligations arising in 1975 were different that the Chirania negotiation failed. The incompatibility is demonstrated by the facts. And it is a fundamental incompatibility because it goes to the very basis on which the negotiation was to take place. So Professor Forto's references to the views of Sir Humphrey Waldock at the time of the Vienna Conference do not help Bolivia at all. It's also untenable to argue as if there was some core of a supposed obligation to negotiate under the Joint Declaration which would not have been conditioned by the accepted basis by which the obligation to negotiate was in fact interpreted and applied by the two states at the relevant time. That is just plain wishful thinking on Bolivia's part. Finally, I also note that Professor Forto referred to Article 65 of the Vienna Convention as if there were a requirement that Chile make a notification under Article 59 of the Convention. and we presume he will be returning on Monday to convince the court that such a requirement existed under customary international law at the relevant time. Mr. President, members of the court, that concludes Chile's submissions on the Tirania process, and I ask that you give the floor to Professor Pinto to continue Chile's first round argument.
I thank you, and I now give the floor to Professor Pinto. Vous avez la parole, madame.
That's okay. Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs de la Cour, c'est toujours un honneur de prendre la parole devant vous. Je le fais aujourd'hui au nom du Chili. Au début de la semaine, les conseils de la Bolivie ont voulu faire croire que les résolutions adoptées par l'Assemblée générale de l'Organisation des États américains ainsi que la conduite du Chili dans les années 1980 ont confirmé ou créé, sur ce point la Bolivie a du mal à prendre position, ont confirmé ou créé, disais-je, une obligation de négocier qui lierait le Chili encore aujourd'hui. Il me revient de vous expliquer pourquoi il n'en est rien et je le ferai en 3 parties. D'abord, je vous démontrerai que les résolutions de l'Assemblée générale de l'OEA sur lesquelles la Bolivie s'appuie n'ont ni réitéré ni créé une quelconque obligation de négocier et de toute façon n'auraient pas pu le faire eu égard à leur nature et à leur portée juridique non contraignante. Aucune obligation de négocier ne découle non plus de la charte de l'OEA sur la base de ces résolutions ou indépendamment de celles-ci. Dans un deuxième temps, j'évoquerai les circonstances dans lesquelles ces résolutions ont été adoptées, circonstances qui ne permettent en aucun cas de transformer ces résolutions en une obligation juridique de négocier ni de créer une telle obligation. Et pour terminer, j'aborderai les processus de dialogue engagés entre le Chili et la Bolivie en dehors de l'organisation régionale dans le but d'améliorer le rapport et auquel la Bolivie a, dès 1987, fait référence sous les termes de el enfoque fresco ou l'approche nouvelle. Mais avant de développer ces 3 points tour à tour, il est utile de faire quelques remarques préliminaires qui, nous semble-t-il, sont indispensables à une meilleure compréhension du sujet, du contexte de ce chapitre des années 80 qui, contrairement aux allégations de nos contradicteurs et amis, ne s'inscrit pas dans une quelconque continuité. La fin des années 70 n'a pas été très lumineuse, ni pour la Bolivie, ni pour le Chili, et certainement pas pour leurs relations bilatérales. M. Wordsworth vient de vous expliquer qu'en 1978, les relations diplomatiques entre les 2 États ont été rompues à l'initiative de la Bolivie. Dans les 2 pays, ce sont des gouvernements militaires qui ont pris le pouvoir au détriment de l'État de droit. Profitant de l'isolement politique du Chili sous le général Pinochet, la Bolivie a tout de suite adopté une stratégie de multilatéralisation pour obtenir un soutien à ses aspirations maritimes et accuser le Chili sur la scène internationale et régionale. Cette politique de dénonciation et accusation au niveau multilatéral a été ouvertement assumée par la Bolivie dès la rupture des relations diplomatiques. La Bolivie a soumis la question de son accès à la mer à l'OEA. Lors de l'Assemblée générale tenue à La Paz en 1979, elle a présenté son rapport sur le problème de l'accès de la Bolivie à la mer, dans lequel elle s'est plaint de son statut d'État sans littoral. Par la suite, l'OEA a adopté 11 résolutions entre 1979 et 1989, une chaque année. La Bolivie omet cependant de préciser qu'aucune résolution sur cette question n'a été adoptée par l'OEA ni avant le coup d'État au Chili, 1973, ni après le retour de la démocratie, ni même en 2012, lors de la dernière Assemblée générale tenue à La Paz. En effet, Monsieur le Président, depuis le retour de la démocratie au Chili, il y a 29 ans, l'organisation régionale n'a donné aucun appui politique, et moins encore juridique, aux aspirations boliviennes. Bien que le sujet soit resté inscrit à l'ordre du jour après 1989 et que la Bolivie ait présenté des rapports contredits par le Chili, l'organisation ne s'est plus exprimée sur le problème maritime. Aucune résolution, aucune recommandation à recourir à des négociations ou au dialogue, aucune reconnaissance de l'existence d'un quelconque différend entre les deux États, aucune réaffirmation de l'intérêt de l'hémisphère concernant le sujet. Monsieur le Président, Mesdames et Messieurs de la Cour, au bénéfice de ces remarques préliminaires, j'en viens à mon premier point. Ces 11 résolutions de l'Assemblée générale de l'OEA n'ont ni créé ni confirmé l'obligation de négocier que la Bolivie revendique aujourd'hui. Ni la Bolivie ni aucun autre État membre de l'OEA n'est tenu les résolutions de l'Assemblée générale pour des instruments autres que des recommandations politiques. En 1979, juste avant l'adoption de la première de ces résolutions, la Bolivie elle-même expliquait qu'il n'y avait aucune raison de transformer, et je cite, une exhortation de l'Assemblée générale en une injonction qui n'existe pas. En 1990, la Bolivie reconnaissait cela sans aucune ambiguïté. Selon les dires du ministre des Affaires étrangères de ce pays, que je vais citer en anglais, "Those resolutions repeatedly affirm that the need to find an adequate solution to Bolivia's maritime confinement is of permanent hemispheric interest. All of this support, which is now part of the history of the successive assemblies of the OAS, has preserved the principles of non-intervention and respect for the sovereignty of states because it has been limited to recommending negotiations between the parties involved, respecting their rights and their self-determination." Cette position quant à la valeur de ces résolutions suffirait à clore le débat. Il n'y a pas eu et il n'y a toujours pas d'obligation de négocier découlant des résolutions de l'OEA. Elle ne mentionne pas une telle obligation et moins encore un différend non résolu entre les deux États. Les résolutions de l'Assemblée générale faisaient et font partie de l'histoire de ce chapitre. Elles sont fonction des circonstances particulières et de l'isolement politique du Chili caractérisant cette période. À ce jour, la Bolivie n'a pas su expliquer pour quelles raisons son appréciation de ces résolutions de l'OEA a changé. Dans son mémoire, la Bolivie a en effet soutenu que les résolutions de l'OEA ont confirmé ou créé une obligation de négocier ayant, et je cite, une valeur juridique et une force contraignante toute particulière. Fin de la citation. Dans la réplique, la Bolivie a cependant admis que les résolutions d'organisations internationales n'ont pas en elles-mêmes de portée juridique contraignante et que l'Assemblée, et je cite, ne peut contraindre les États à adopter un comportement précis. Fin de la citation. Bien sûr, le Chili en a pris acte dans sa duplique. Néanmoins, mardi matin, Ms. Sender s'est distancée de cette position tout en développant une nouvelle thèse sur la base des dispositions et obligations de la Charte de l'OEA relative au règlement pacifique des différends. Selon Ms. Sender, Ces obligations étaient seulement réitérées par les recommandations de l'Assemblée générale, recommandations qui auraient été acceptées par le Chili et en tout état de cause les liaient indépendamment d'une acceptation, voire malgré ses votes négatifs. Ces raisonnements, qui est en tout point conforme à celui du professeur Lowe concernant l'article 2, paragraphe 3 de la Charte des Nations unies, est artificiel. Il ne constitue qu'une nouvelle tentative de trouver un fondement en droit international à l'existence de l'obligation de négocier que la Bolivie demande à la Cour de confirmer. Aucune des 11 résolutions invoquées par la Bolivie, aucune, Monsieur le Président, ne mentionne une quelconque obligation de négocier. Aucune ne confirme l'existence d'une obligation de négocier et aucune ne crée une telle obligation. La Bolivie elle-même ne cherchait pas à engager de nouvelles négociations. Le rapport sur le problème de l'accès de la Bolivie à la mer ne fait pas mention de nouvelles négociations et encore moins d'une obligation de négocier. La Bolivie considérait alors que ses aspirations, son soi-disant droit, n'étaient justement pas négociables et qu'elle ne voulait plus des prétendues négociations généreuses. Je viens de le dire, le texte de résolution de l'Assemblée générale n'utilise pas le terme « obligation ». L'organe plénier parle seulement d'un intérêt permanent du continent, d'un esprit de fraternité. Il recommande aux États concernés d'entamer des négociations, invite instamment les États concernés à ouvrir par les voies appropriées un dialogue, ou décide d'exhorter la Bolivie et le Chili à entamer, dans un esprit de fraternité américaine, un processus de rapprochement. Rien dans les recommandations ne confirme l'existence ni établit une obligation de négocier qui pourrait être transformée en obligation contraignante pour le Chili et la Bolivie. Il s'agit seulement d'aspirations politiques et les termes utilisés le confirment. Mardi matin, Miss Sunder n'a pas affirmé le contraire. Plutôt que de rechercher la source de l'obligation de négocier dans les textes de résolution, elle vous a renvoyé aux dispositions de l'article 3I et 24 de la Charte de l'OEA. Je ne vais pas m'attarder sur l'essence et la portée de ces dispositions. Sir Daniel et le professeur Touvenin ont d'ores et déjà présenté notre position sur la question dans le cadre de la Charte des Nations unies et il n'y a pas de raison de revenir là-dessus. Mais, Monsieur le Président, rien ne permet d'affirmer qu'en adoptant ces 11 résolutions, l'Assemblée générale de l'OEA agissait dans le cadre de l'objectif de résoudre des différends entre États membres, compétence qui, par ailleurs, n'est pas dévolue à l'Assemblée, mais au Conseil permanent. Les résolutions n'utilisent pas le terme « différend » ou « controverse » et dans la grande majorité des cas font seulement référence aux, et je cite, « États directement concernés par le problème ». Or, ni le Chili ni l'Assemblée générale de l'OEA n'ont reconnu l'existence d'un différend ou d'une controverse entre les deux États, mais seulement d'un problème ou de nombreuses difficultés qui les séparaient. Au risque de déplaire au professeur Remiro Brotons, il ne s'agit pas de jouer sur les mots. Et les mots sont importants, Monsieur le Président. C'est une cour de droit sur laquelle on s'adresse aujourd'hui. L'Assemblée a bien choisi les termes employés et surtout celles qu'elle n'a pas voulu employer. Il a justement refusé de se référer au chapitre 5 de la Charte de l'OEA, référence qui figurait pourtant dans les projets de résolution soumis par la Bolivie en 1979. La Bolivie, le Chili et la Colombie ont également décidé de ne pas retenir une référence à l'article 24 de la Charte dans le projet de résolution adopté en 1983 visant le rapprochement de deux États. Les résolutions de l'Assemblée ne s'inscrivent tout simplement pas dans la logique de l'article 3 ou de l'article 24 de la Charte et la Bolivie ne peut pas changer leur objet et but ex post facto devant la Cour. L'obligation de considérer la recommandation de l'Assemblée générale, qui selon la Bolivie est inhérente au statut d'État membre de l'OEA, ne change rien à l'effet juridique de ces résolutions. La Bolivie fait grand cas de l'opinion individuelle du juge Lauterpacht, jointe au premier avis consultatif sur le sud-ouest africain. Mais il a également et avant tout pris soin de confirmer dans son opinion, et je cite, qu'un État n'est pas tenu d'accepter une recommandation et qu'il n'y a pas d'obligation d'accepter sans réserve une recommandation ou une série de recommandations particulières. Fin de la citation. Examiner une résolution de bonne foi n'implique aucunement une obligation d'accepter comme juridiquement contraignant son contenu. L'effet juridique contraignant qui fait défaut à une recommandation ne peut être réintroduit par les biais d'une soi-disant obligation de la prendre en considération. La dernière des résolutions adoptées par l'Assemblée générale de l'OEA en 1989, l'année qui précède la restauration de la démocratie au Chili, confirme qu'il n'y a ni obligation de négocier, ni différend, et certainement pas des différends sur l'accès souverain de la Bolivie à la mer. Ms. Sender a projeté les textes de la résolution sans pour autant vous lire la partie la plus importante. Vous l'avez à nouveau sur vos écrans et à l'onglet 73 de vos dossiers de plaidoirie. L'Assemblée souligne seulement l'importance que revêt la solution du problème de l'accès de la Bolivie à la mer sur des bases qui prennent en considération le besoin réciproque ainsi que le droit et intérêt de parties concernées. L'Assemblée ne mentionne aucune obligation préexistante de négocier. Elle ne mentionne qu'un problème et non pas un différend. Elle n'est visée qu'à assurer une meilleure entente et une plus grande solidarité et intégration du continent, des objectifs éminemment politiques. Plutôt que d'imposer une obligation de négocier, l'organe principal de l'OEA exhortait les parties au dialogue. Il est bien difficile d'imaginer que ce terme politique par nature ait été choisi pour imposer au Chili des obligations juridiquement contraignantes concernant des négociations aboutissant à un accord sur l'accès à la mer. Les presque 30 années de silence de la part de l'OEA corroborent l'absence d'une telle obligation dans l'appréciation de l'organisation régionale qui, faut-il le rappeler, aurait été seule habilitée à vérifier l'exécution et le respect d'un engagement pris à son égard. Conscient des lacunes de sa thèse, et ceci est mon deuxième point, la Bolivie a recours à une autre construction artificielle selon laquelle la conduite du Chili pendant la rédaction et l'adoption des résolutions aurait eu pour effet de cristalliser ou de faire naître un accord entre les deux États ou que cette conduite aurait donné naissance à des attentes légitimes de la Bolivie, bien sûr, en vertu desquelles le Chili ne pourrait plus changer sa conduite aujourd'hui. La Bolivie considère qu'un vote positif de la part d'un État peut transformer une simple recommandation en instrument obligatoire. Une telle proposition ignore la réalité de la vie diplomatique et des hémicycles des organisations internationales. Aucun représentant ne le fait dans l'intention et la conscience de lier juridiquement son État au contenu d'une résolution qui est en tant que telle dépourvue d'effets juridiques. La Bolivie croit trouver un précédent dans l'affaire de la dévancière de la Cour relative au trafic ferroviaire entre la Lituanie et la Pologne concernant une résolution du Conseil de la Société des Nations. Comme Mme Sander l'a expliqué, la Pologne et la Lituanie avaient accepté explicitement les termes et les contenus de la dite résolution. La Cour permanente a rappelé que les deux États ont participé à l'adoption de cette résolution du Conseil. Pourtant, pour la Cour permanente, les deux États, et seulement ces deux États d'ailleurs, étaient liés en vertu de leur acceptation de la résolution du Conseil. En d'autres termes, le seul vote positif de la part de la Pologne et de la Lituanie n'était pas suffisant pour juridiquement lier les deux États à la résolution, dont les compétences du Conseil de la Société des Nations étaient très différentes de celle de l'Assemblée générale de l'OEA. Monsieur le Président, Mesdames et Messieurs de la Cour, la situation du Chili et de la Bolivie est tout à fait différente. Le Chili n'a jamais accepté une obligation de négocier l'accès de la Bolivie à la mer. Il n'a même pas jamais voté en faveur de ces résolutions. Bien au contraire, Monsieur le Président, le Chili a voté contre les résolutions en 1979 et entre 1984 et 1989. En 1982, le Chili a refusé de participer au vote de la résolution et exposé sa position dans une déclaration. En 1980, 81 et 83, il ne s'est pas opposé au consensus sans pour autant voter pour les résolutions. Il a par ailleurs très clairement contesté la compétence de l'Assemblée générale en la matière, comme il l'avait déjà fait en 1979. Il est difficile, pour ne pas dire impossible, d'établir sur cette base une quelconque acceptation du contenu de ces résolutions. Tout au plus, les objections du Chili confirment qu'il ne s'agit pas d'une question et encore moins d'un différend qui entrait dans la compétence de l'OEA. À tout état de cause, comme je viens de l'expliquer, les termes mêmes de résolution ne mentionnent aucunement une obligation de négocier qui pouvait être acceptée ou transformée en obligation contraignante. Même en 1983, en participant à l'élaboration de la résolution 686 et en ne s'opposant pas au consensus au sein de l'Assemblée, le Chili n'a aucunement accepté une obligation de négocier l'accès à la mer. Le texte de cette résolution, consciencieusement établi entre les deux États, ne laisse aucun doute. Il exhortait le Chili et la Bolivie, et je cite, à entamer dans un esprit de fraternité américaine un processus de rapprochement des peuples boliviens et chiliens et de resserrement de leurs liens d'amitié. Les événements des années 83, 84 et 85 confirment que ces processus de rapprochement avaient été considérés comme l'élément clé de cette résolution. L'objectif du Chili était de rétablir des relations normales avec la Bolivie à travers un dialogue constructif. C'était la condition sine qua non pour des discussions concernant le soi-disant problème maritime de la Bolivie. Cette interprétation n'était pas seulement celle du Chili, mais également celle de la Colombie, qui jouait un rôle important dans ces processus. Si jamais il y avait eu une telle acceptation ne pouvait concerner que cela, l'engagement d'un processus de rapprochement. Monsieur le Président, le Chili n'a pas voté en faveur de résolutions. Il ne les a pas acceptées comme obligatoires et il n'a pas non plus créé d'attentes légitimes quant aux négociations portant sur un accès à la mer pour la Bolivie. Les résolutions de l'Assemblée générale de l'OEA et la conduite du Chili pendant leur adoption sont absolument incapables d'établir une obligation juridique, que ce soit par forclusion, par acquiescement, par une soi-disant doctrine des attentes légitimes ou par les biais de l'obligation de règlement pacifique des différends. En effet, et je me permets de paraphraser l'arrêt de la Cour des séances dans l'affaire des activités militaires et paramilitaires, les résolutions de l'Assemblée générale ne sont que des simples déclarations politiques ne comportant pas d'offre formelle pouvant constituer, par son acceptation, une promesse en droit et donc une obligation juridique. Et la Bolivie n'a pas davantage prouvé l'existence d'un instrument ayant une valeur juridique unilatérale ou synallagmatique par lequel le Chili se serait engagé. Monsieur le Président, ça m'amène à mon troisième point, un court épisode du processus de discussion entre le Chili et la Bolivie engagé dans les années 1986 et 1987 dans un cadre purement bilatéral et donc en dehors de l'OEA. Cette approche nouvelle n'a pas non plus pu créer ou confirmer l'existence d'une obligation de négocier un accès souverain à la mer. Cette nouvelle approche fut initiée en février 1986 par le nouveau président bolivien, Paz Estenssoro. Il ne s'agissait pas, dans l'esprit de la Bolivie elle-même, d'une continuité des négociations antérieures et encore moins d'une confirmation d'un engagement non existant de négocier, comme le professeur Forteau a voulu le faire croire. Plutôt que d'insister sur la mise en œuvre d'une obligation préexistante de négocier un accès à la mer, cette approche nouvelle, comme son nom l'indique, était véritablement différente et en rupture avec les stéréotypes du passé, pour reprendre le terme utilisé par mon collègue, le professeur Remiro Brotons. Il visait un rapprochement des intérêts de la Bolivie et du Chili dans une multitude de domaines, dont l'un était l'accès à la mer. Le Chili s'est engagé de bonne foi dans un dialogue important avec la Bolivie, dans le contexte de relations de bon voisinage qu'il souhaitait entretenir avec elle, car tous deux souhaitaient améliorer leurs relations dans les différents domaines. Rien ne permet d'affirmer que la Bolivie considérait que le Chili était obligé d'une quelconque façon à engager ces dialogues. Aucune obligation de négocier n'a été évoquée par les deux parties. Aucune attente quant à l'octroi d'un accès territorial à la mer n'a pu être créée dans ce contexte. Concernant justement l'accès à la mer, la Bolivie a soumis plusieurs propositions au Chili, impliquant toute une cession d'une partie de son territoire. Le Chili a soigneusement considéré ces propositions, il a formulé des questions auxquelles la Bolivie a répondu, il a engagé de consultations au niveau interne. Toutefois, il est devenu rapidement évident que la cession d'une partie du territoire chilien était, pour le peuple chilien, inacceptable. Si le Chili s'est proposé de continuer les discussions pour trouver d'autres moyens d'améliorer les relations entre les parties, la Bolivie a purement et simplement refusé de continuer les dialogues sur des bases autres que celles d'une cession de territoire. Pendant cette courte période de discussion et de rapprochement, le Chili n'a pas assumé des obligations juridiques quant aux négociations sur un accès à la mer et n'a pas non plus violé une quelconque obligation de négocier. Au contraire, le comportement du Chili est en tout point conforme aux éléments de négociation de bonne foi évoqués par le professeur Lowe lundi matin. Qui plus est, Monsieur le Président, l'attitude du Chili dans ces discussions dans le cadre de l'approche nouvelle n'a pas pu créer, renforcer ou nourrir des attentes légitimes de la Bolivie. Bien au contraire, la déclaration du ministre des Affaires étrangères du Chili de 1987 ne laissait aucun doute. Le ministre expliquait, et je vais le citer en anglais, "The substance of the Bolivian proposal is not acceptable for Chile in either of its alternatives. Chile understands that it may collaborate with said country in the search for solutions that, without altering the national, territorial, or maritime patrimony, would allow for a bilateral integration that would effectively serve the development and well-being of the respective countries. The government of Chile deems its duty to explain these details, since it does not consider it fair, with its silence or delay, to generate confusion for the national public or to give rise to false expectations of the Bolivian government and people that would, in time, be frustrated." Cette déclaration ne pouvait guère être plus explicite. Aucune attente ne pouvait naître des déclarations ou de la conduite du Chili lors de ces échanges dans le cadre de l'approche nouvelle. Monsieur le Président, Mesdames et Messieurs de la Cour, aucune obligation de négocier n'a été créée en vertu des résolutions de l'OEA, de l'attitude du Chili vis-à-vis de ces résolutions. L'approche nouvelle n'a pas non plus établi une telle obligation, ni la Bolivie ni l'OEA n'ont mentionné une telle obligation ou soit violation. Monsieur le Président, Mesdames et Messieurs de la Cour, je vous remercie pour votre bienveillante attention. Monsieur le Président, je vous prie d'appeler mon collègue Ben Juratovic à la barre, sûrement après la pause. Merci, Monsieur le Président.
I thank Professor Pinto. Before I invite the next speaker to take the floor, the court will observe a coffee break of 15 minutes. The hearing is suspended.